My message today, to get right to the bottom line, is if what happened to Senator Ted Stevens, a powerful senator, we eventually had 12 members of the defense team. We had a courageous, heroic judge who made a lot of brave decisions in the case. A few blocks from the Supreme Court of the United States, a few blocks from the United States Capitol. If it can happen to him, it can happen to anybody. It can happen to Michael Morton, it can happen to Hannah Overton, and it can happen to any citizen. So let me tell you the story of the Stevens case. There was a cooperator in the case, a guy by the name of Bill Allen, who was caught up in something called Operation Polar Pen. Operation Polar Pen started as an investigation of whether private prisons in Alaska, there was corruption with respect to the rewarding of private prison contracts in Alaska, and it led to a construction company by the name of VICO. VICO was founded by this man, Bill Allen, who was not a billionaire, but a 100-millionaire. And Allen was a friend of Ted Stevens. He was also a friend, or there's another friend who will figure into the story, a guy by the name of Bob Persons. And Bob Persons and Bill Allen offered to look after the renovations of Ted Stevens' modest cabin. I'll show you a picture of it here in a few minutes, back in Alaska while the senator did his work in Washington, D.C. Allen, unbeknownst to Senator Stevens, had a dark side. He was paying cash to Alaska state legislators. That was caught on undercover video surveillance. He also was overheard talking to his son, planning the murder of a nephew of his, which subjected him to conspiracy to commit murder charges. He was confronted by the FBI on August 30th, 2006. There was no record made of that confrontation, but he did what most people would do when confronted by the FBI in the face of the evidence against him, and he cut a deal. He entered into a plea agreement in which he agreed, the government agreed that they would not charge Allen's son, Mark Allen, or other members of Allen's family for any crimes. So, you know, as lawyers, as defense lawyers, we often think, well, we can prove that somebody would have a motive to lie to increase or decrease their own incarceration. Imagine if somebody confronted you and said, your own son's going to go to jail unless you cooperate with us. An incredible incentive, an incredible benefit. They also agreed that they would view Allen's cooperation as being cooperation on the part of VICO. VICO had government contracts. It was subject to disbarment. It could have been put out of business by the government if they'd wanted to. They said, if you cooperate with us, we will consider it cooperation on the part of your company. Allen was able, during the course of this investigation in the days leading up to the trial, to sell the company for $400 million. The purchaser put a $70 million holdback in the contract, the sales contract, to make sure that he continued to cooperate with the government. Imagine those incentives, $70 million worth of incentives. Also might add that Mark Allen, after our trial, with the freedom that he got from the deal that his father cut, and the money that he got from the sale of the company as well, bought a horse that won the 2009 Kentucky Derby, something that happened just about a month after the senator was exonerated and received very little mention in the press. Allen also had the possibility of getting a 5K1 deal, a substantial cooperation agreement which would have allowed the government or the judge to depart completely from the sentencing guidelines, in addition to a reduced sentence on the sentencing guidelines. He had the ability to sell his company for hundreds of millions of dollars, and he got immunity for his children. There was another thing about Bill Allen that was going on at this time that we knew about, and that was that he was being investigated for engaging underage prostitutes in the state of Alaska. The trial took place, the indictment was in July 2008, the trial was in September 2008. This is the headline from a very reputable media outlet called TPM Muckraker. But we knew at the time that Bill Allen was being investigated, and that will figure into the story as we go forward. So let me tell you about the case. The allegations were that there were free cabin renovations put on Ted Stevens' cabin by workers at Allen's company, and that he failed to disclose those as gifts on his Senate disclosure form. There was no bribery charge. There was no illegal gratuities charge. There was no honest services fraud charge. It was simply straight up 18 U.S.C. 1001. They said, you got something for nothing. You got these free renovations. You should have disclosed that on your Senate disclosure form. What were our by the way, this indictment was 98 days before he was to stand for election for his 7th term in the United States Senate. The defense was, here's a copy or a picture of the cabin, very modest cabin. Everybody ever took to the cabin said, I can't believe that this was the official residence of a United States senator. The amount paid was $162,000 for the renovations. The senator and his wife paid every bill that was presented promptly. As soon as it was presented, there was one bill that Bob Persons, who was funneling the bills to him, said, boy, this seems a little high to me. They said, no, we want to pay it. We want to make sure we pay for everything we got. The building permit estimated the value of the renovations at $87,000. That turned out to be a little low. The assessor for the state of Alaska estimated for tax purposes the value of the renovations to be $104,000 contemporaneously at the time. The appraiser for the bank, they actually borrowed money to do the renovation, estimated the value to be $115,000. And the appraiser said, my best estimate of what it would cost was $123,000. So from the senator's perspective, they paid more than what was due. In addition, or more than it was worth. They paid every bill as it was presented to them, every bill they ever saw. In addition, we had outstanding character witnesses. We had Senator Colin Powell, who testified that he'd known Senator Stevens for 30 years. He had a sterling reputation for integrity. We had Senator Dan Inouye, a Democrat. Stevens was a Republican, his best friend in the Senate, who testified that he would give his life for Senator Stevens. We had Orrin Hatch testify for him. We would have had Ted Kennedy, but his health did not allow it. We also considered and thought that Joe Biden would have been willing to do it. We made the decision that might have been too much of a circus because he was actually running for vice president at the time, and we would have had too many fights with his staff. But Biden actually is the sort of guy, this is the old Senate where the Democrats and the Republicans got along, and they were very, very dear friends. The heart of our defense was this note, which was we produced to the government before indictment. It's to Bill Allen from Ted Stevens talking about his friend Bob Persons, and it says, you owe me a bill. Remember Torricelli, my friend. Friendship is one thing. Compliance with these ethics rules entirely different. I asked Bob Persons, the other friend who was overlooking the renovations, to talk to you about this, so don't get PO'd at him. It just has to be done right. That was labeled Exhibit 495 in the trial, which happens to be the number of the Capitol Beltway that surrounds Washington. We told the jury every chance we got, this is the most important piece of evidence in the case. It's a snapshot into the mind of an innocent man. It shows, in addition to what I showed you before about he paid more than the value, it shows that he wanted everything done right. We thought it was a very powerful piece of evidence. What was the government's response to this? First of all, they had billing records to show that people from Allen's company spent $188,000 worth of time down there that was in fact not put on the bills. We'd heard rumors that people were screwing around, that it was a place where people could just record their time and would not actually do any work when they were down there, but those were the bills that they put in evidence, said, look, he got at least $188,000 worth of work for nothing. Their other response was testimony from Bill Allen that was delivered right before break. He was answered or asked, question, did you send Senator Stevens a bill or an invoice after you received this note from him? Answer, no. Question, Mr. Allen, do you remember having the conversations with Mr. Persons after you got the note from Senator Stevens? Answer, yes. Question, what did Mr. Persons tell you? Answer, he said, oh, Bill, don't worry about getting a bill. He said Ted is just, quote, covering his ass, end of quote. It was devastating testimony to us. We'd emphasized this note as being the heart of our defense, and they took what we had told the jury was our best piece of evidence of the state of mind of an innocent man, and they immediately turned it into evidence of a cover-up. In a snapshot, in a snap second, they took our best evidence and tried to turn it into their best evidence. And to tell you a little more about how the case was tried, the Senator Stevens was cross-examined. He was asked twice on cross-examination, you were just trying to cover your bottom when you wrote this note. Isn't that true, Senator Stevens? He uttered back or rejoined back. He says, my bottom wasn't bare, which he was very proud of that. He was very angry. His lawyers, we weren't so thrilled with that. We didn't think it was the right impression to give the jury, but it was very much a part of their theme. They used the word cover 14 times in their closing statements. Their theme was the senator was just covering his ass. That's what senators do in Washington, D.C. Let me tell you about some of the issues that happened during the trial. We had lots and lots of arguments about discovery. I was with Judge Emmett Sullivan, the presiding judge, who was a hero in this case. I guess, I think it was just yesterday, believe it or not, who believes that we filed 28 motions to dismiss. In fact, I think it was only about 10. But there were many discovery issues in the case. Let me tell you one. They refused to discover or refused to organize the electronic files in the case. And you'll hear more about that later, what the investigations found out about that. They refused to give us an index of the undercover surveillance, both video and wire surveillance. If we'd had one person spend every minute of their life, we tried this case 6 weeks after indictment. It would have taken a year for somebody to get through all that, and they refused to provide an index. They finally, we went to Judge Sullivan and ordered them to provide an index, and they gave it to us, and they said, but it's not a very good index. You can't count on it. The only way you can do this is to go through it yourself. Fortunately, in my law firm, we had a lot of summer clerks who were very interested in working on this case, and they ordered a lot of pizza and sat in a room and figured out whose voice was who, and they got through it all. But something that most people don't have, right? They refused to turn over any interview memos. The most basic thing you need to know in a case, what did the witnesses say? They insisted that turning over summaries that they prepared, that the assistant U.S. attorneys prepared, was sufficient. We argue I can't cross-examine with a letter from an assistant U.S. attorney. I need the witness so I can impeach with the FBI agent later. And eventually Judge Sullivan turned those over. But what they then did is they insisted on redacting everything from the interview memo that they didn't consider Brady information. So we would get a 10-page interview memo that was 9 pages of stuff blacked out and maybe 3 lines that they considered potentially to be Brady. With respect to the sex investigation, the underage sex investigation I mentioned earlier, they said we suspected that his cooperation deal might have something to do with that. They said it did not. We never found any evidence that it did, although I still think it was hanging over him like this sword of Damocles throughout this whole trial. But what they did do is, in their summary letter, they said there's a rumor that Allen suborned perjury from one of his from an underage prostitute. We've looked into that thoroughly, and there's absolutely no evidence of that. You'll later learn that that was false. Based on that representation of the government, which we were helpless to challenge and that Judge Sullivan accepted, we weren't allowed to ask about the sex investigation during the trial. I got a call from one of the workers on the first weekend of trial who called me and said, I'm in Alaska. I was in Washington, D.C. for 10 days. His name was Rocky Williams. And I wanted you to know that after spending 10 days here, the government flew me back to Alaska. He was actually under subpoena from us. He did have some health issues. The government said we flew him back because of his health issues. In fact, last time I checked, Johns Hopkins was the #1 ranked hospital in the world, which is very near to our federal courthouse. And the idea of flying him back to Alaska for health reasons did not ring true to us. It turns out he told me that a lot of the time that I recorded as being there, I actually wasn't there. I just used that as a place to record my time. Very clearly Brady information. And that really began a series of events where I think Judge Sullivan concluded he couldn't really trust what the government was telling him. Because of that, there's another incident that came up in the middle of trial, and we got a 302 because an FBI agent, not the kind of the number 3 or number 4 FBI agent on the case, was going to testify as a summary witness. We got all of her statements, and it turned out that there was Brady information in there where Bill Allen said Ted Stevens would have paid any bill I ever gave him, that they had affirmatively redacted out with a black marker. Because of that, the judge then ordered all statements in unredacted form produced and all grand jury testimony. We then found another person, the person who spent the most time of that $188,000 at the cabin, supposedly, in fact, was not in the state of Alaska at all during that time period because it contradicted his grand jury testimony. Our defense was, when we heard this terrible statement about Ted was just covering his ass, our belief was it was a recent fabrication. That's what we argued to the jury. That's what we believed. We asked Bill Allen during cross-examination, when did you tell the government this for the first time? It was just recently, wasn't it? And he said no. And we were powerless to challenge that because we didn't have the evidence to challenge it. You know, the Supreme Court, I think as John Henry Wigmore says, that the greatest cross-examination is the greatest legal engine ever invented for discovery of the truth. And the Supreme Court calls it the crucible under which we find the truth. That's all correct so far, but without the evidence to challenge the witness, it wasn't very helpful to us. The government played on the prosecutors played on cynicism of government officials, especially in Washington, D.C. By the way, we're trying this case representing a Republican in the District of Columbia, which is about 98% Democratic. They compared him to a 6-year-old in closing arguments. They made fun of him for stuttering. When he would get angry at what was happening, he would stutter. And they basically suggested that nobody can survive in the United States sentence or in the United States Senate for as long as he did without being corrupt. That was the theme. The jury found the senator guilty 8 days before he was to stand for re-election. He went back to Alaska, and by the way, just one quick aside, we had I would call them tumultuous jury deliberations. There were notes that there was threats of violence in the jury room, and then one of the jurors actually left in the middle of deliberations, said her father had died. In fact, she went to the Breeders' Cup in California. And that, believe it or not, came to light after the trial, but before the election, and people in Alaska were quite angry, and Ted Stevens actually won re-election on voting day in Alaska, but the early votes and the absentee votes were so solidly against him because of the indictment that he actually lost by about 1%. And it actually affected the balance of power in the United States Senate. The real work, as Judge Sullivan likes to say, began after the trial was over. On the day that our motion for a new trial was due, we got an email from the government. Well, actually, there's one thing that happened first, and a lot of this is cascading, and you know, sort of the momentum was building up more and more. One witness, that wasn't that important witness, wrote an open letter to the judge saying I was given immunity by the government, but told to sweep it under the rug. And he wasn't a super important witness. I don't think that was maybe the most important thing in the case, but it was just one more thing that began to build. But the real break in the case happened on the day our new trial motion was due. We got an email about 3 o'clock in the afternoon from the government that says we have some new information. We're presently studying what our obligations are with respect to that information. We're confident it will not affect the verdict, but we wanted to let you know that we'll be giving you some new information next week. And Judge Sullivan graciously said, if you want more time to file your new trial motion, I'll give it to you. Having only 2 hours to go, having it all ready, we were paranoid about waiving jurisdiction or something, even with the judge's blessing, so we said, we'll go ahead and file. About 10 days later, the government sent us another heavily redacted document that purported to be a whistleblower complaint on behalf of the number 2 FBI agent on the case, in which he essentially alleged that there was an improper relationship between the lead FBI agent and a number of witnesses, that sending Rocky Williams back to Alaska was intentional because his mock cross-examination had gone poorly. To this day, I don't know what happened to that mock cross-examination, but my guess is there was some Brady material in there. And that there were improper relationships between the government and the press, and moreover that the Brady violations were intentional, that had been discovered and in some ways remedied during the trial, because in fact we did get it before we closed and we had an opportunity to use it, although I would argue, and we argued it before Judge Sullivan, that it was very difficult to shift your strategy in the middle of the case when you don't get it till the middle of trial. That led to a series of sort of crazy events. The first thing that happened is Judge Sullivan ordered that we get an unredacted copy and was quite stern with them. How can you continue to redact after what happened in this case before? They weren't going to give it to us unredacted in the first place. And then the government argued that it should still be held under seal from the public. Our position there was they had a website on the DOJ website devoted to this case. They went after Senator Stevens the most public way possible. Now that the tables were turned, the public should know about this as well. And after about a month of around-the-clock litigation, Judge Sullivan decided that almost all of the whistleblower complaint would be disclosed to the to the public. But based on their representations that the FBI agent was a whistleblower who was entitled to anonymous treatment, that his name, his name is Chad Joy, it's all public now, would not be disclosed to the public. So we filed a new motion to dismiss, now incorporating all the information, but using gender-neutral terms and not disclosing too much about who the FBI agent was. 2 days before before the government's response was due, they sent an email to us and the judge saying, you know, we've reconsidered and we think that we ought to be able to use Chad Joy's name after all. We don't think he's entitled to anonymous whistleblower treatment. Now, this sounds like sort of a collateral issue in many ways, but it's amazing what happened next. We go to court. Our position is that's fine, but we should get to refile, use his name, not write with one arm tied behind our back, and then you can respond. And we won that argument. The judge took a recess, and he came back out. And this is the only time during the entire trial that the press was not there because there was almost no notice of this hearing. And he came back out and he says, I just have one question for the government. I want to know when you decided that this witness or that this Mr. Joy was not entitled to anonymous treatment anymore. And they couldn't give a straight answer. There were 3 prosecutors. They all said something a little different. They couldn't figure it out. And it upset the judge, rightly so. He said, we pulled all-nighters during the month of December trying to figure this out. And now you tell me it doesn't matter. And I want this is the Thursday before inauguration. He says, I want a declaration from the Attorney General of the United States by Monday. I understand that it's the waning days of the administration. I want it from this Attorney General, not the next Attorney General, disclosing who knew what and when about the status of this whistleblower, because you had an obligation to come clean with us and do it before that. The DOJ took an emergency motion up to the D.C. Circuit, which understandably stayed the order, not knowing what to do. But Judge Sullivan worked very hard on Inauguration Day and wrote a new 20-page order saying, I can't require that declaration anymore, but now what I want is every piece of paper from the Department of Justice about who knew what and when about the status of this whistleblower. About a week later, they produced that to the judge, but defied his order to produce it to the defense. And for the first time in the case, we asked for the government team, actually not the individual lawyers, to be held in contempt. And the judge granted that motion, held them in contempt. As he said just yesterday, I asked them why, and they couldn't give me a reason why they defied his order. That led to new prosecutors being appointed to the team, and everything started to change. A gentleman who's one of the heroes of the story by the name of Paul O'Brien, who was then head of narcotics and dangerous drugs in the Department of Justice, got made the new head of the Stevens prosecution team, and every few days more information would come to us. And one day, Paul O'Brien walked up from the Justice Department to my office, and I never had a prosecutor show up in my office in Washington, D.C. unannounced. Asked to see me. I went down to the reception desk, and he showed me a stack of papers, and he pointed to an email. He says, I want you to pay careful attention to this. And he says to me, he says, trust me, we're looking for the interview memo. We haven't found it yet, but the minute we find it, you'll get it. And it was an email between prosecutors in Washington, D.C. and prosecutors in Alaska who are clearly talking to Bill Allen. They're talking about the it just has to be done right note. They're clearly not satisfied with his answers, and they decide to terminate the interview, talk to the lawyer, and see if they can get a better answer out of him. A few days after that, so I got the emails. A few days after that, he came back to me and he said, we never did find an interview memo. Apparently one was never done. But I have found some prosecutor's notes. And those prosecutor notes revealed that Allen had absolutely no memory of the discussion with Bob Persons. The keystone of their case, the heart of their case, the theme of their case, 180 degrees opposite. And then those notes also said that the workers were always drunk, they screwed it up, and the fair market value of the work was about $80,000. Based on that, the Attorney General of the United States made a courageous and correct decision and decided to have the case dismissed. Judge Sullivan was just reflecting on this yesterday. He decided to have a hearing 6 days later to do this publicly. It didn't seem like the right way for it just to go away with a consented to order, so we had a hearing in federal court. Ted Stevens appeared. Judge Sullivan called it the worst case of prosecutorial misconduct he'd ever seen. He appointed an independent prosecutor, a gentleman by the name of Hank Schulke, a real legend in the Washington, D.C. bar, to conduct an investigation. And he said, and then the senator spoke, and he said these words, quote, "It is my hope that when the dust settles, I may be able to encourage the enactment of legislation to reform laws relating to the responsibilities and duties of those entrusted with the solemn task of enforcing criminal laws." He was a former U.S. attorney himself in the territory of Alaska before Alaska was a state, and He could not believe what had happened to him, and he wanted to make sure that it didn't happen to others. That was April 9th, 2009. 16 months later, the senator before, and what he meant by the dust settling is he wanted to see what this investigation revealed. 16 months later, before the investigation was concluded, he was killed in a plane crash. A month after that, 2 days before he was supposed to be buried in Arlington National Cemetery, one of the prosecutors committed suicide. We continue to wait for the results of the investigation. They eventually came about 2.5 years after the dismissal of the case. Hank Schulke and his partner Bill Shields worked tirelessly on the investigation. The DOJ Office of Professional Responsibility also did a very professional and first-rate investigation. There were over 1,000 pages of investigative results. Bill Shields himself worked literally every day, including holidays and weekends, for 2.5 years to get this done. What they concluded was that there was a systemic concealment of evidence that would have corroborated the defense and damaged the credibility of the chief witness, Bill Allen. Remember that we knew going into this investigation that Allen had no memory of the covering his ass testimony that he described, but here's what Schulke found. First of all, they found that there was evidence that Allen suborned perjury from an underage prostitute. It turns out that there was an FBI 302 memo in the file in which the underage prostitute, Allen's victim, said that Bill Allen paid me $5,000 to submit a false affidavit saying I never had sex with him, something that would have been used in devastating effect in a trial against Ted Stevens. Rocky Williams, the guy they sent back to Alaska, believed that all costs reflected on the bills were reflected on the bills, and he discussed that with Ted Stevens. That was important because Ted Stevens testified to that. He thought everything was on the bills. Catherine Stevens testified to that. In fact, Rocky Williams said everything's on the bills. We know from notes that they told the government that. We would have been able to call Rocky Williams and corroborate that, but we weren't able to because we didn't know, because they never disclosed it to us. And there were notes, but no FBI interview memo, which is a violation of FBI regs, that there's supposed to be a memo of witness interviews. Allen argued constantly with the government about the value of renovations. He thought they were worth much less than the government charged. That was not disclosed to us. We would have, if we had been able to cross-examine Allen with that, it would have been very helpful to the defense. We learned that Allen came up with this covering his ass story 8 days before trial while under pressure from an FBI agent. It was actually on his private plane that he was flying back with the FBI agent to Washington, D.C. We also learned in the report that he was paranoid and very concerned about the underage sex investigation, and if asked about it at trial, would have asserted his Fifth Amendment privilege. Finally, we learned that the prosecutor ordered the electronic, or one of the prosecutors ordered the electronic files scrambled and disorganized, something that I suspected, I forget whether I told you at the beginning, but they were terribly disorganized when we got them. We went to Judge Sullivan. I did not say it was intentional. They claimed it wasn't intentional. We learned from an from a DOJ technology consultant that she had them neatly organized in files for the defense, something I know you talked about in your first session today. And he said, no, I don't want to do it that way. I want them scrambled. I want them disorganized for this defense team. So what did the investigations conclude about the prosecutors? Recall that one tragically had committed suicide. Schulke investigations said that this was intentional misconduct. That's the independent investigation. But no clear order was violated. His charge was to determine whether criminal contempt was appropriate, and he found that Judge Sullivan had not issued a clear, unambiguous order to produce the Brady information. Of course, no federal judge should need to issue such an order. A prosecutor should abide by the Constitution, but that was his finding. The DOJ investigation basically had the same facts in it, but they concluded that the mens rea of the prosecutors was reckless, non-intentional. They ordered a 40-day suspension of one of the prosecutors, a 15-day suspension of the other. But just within the past 3 months, a court has struck down those suspensions because the department did not follow its own internal policies when they imposed the sentences. So those have been taken away. So I'll end, and I'll take a few questions if we have time, by saying if this can happen to a powerful U.S. Senator in Washington, D.C. with 12 defense lawyers, as the case went on, more and more people would come into my office and say, I want to help. I understand you need help. It can happen to anybody. And I think likely has. It happened to Michael. It happened to Hannah. And we know from the Innocence Project's work that it's happened to hundreds of others. It's my belief that there are thousands of people in prison for crimes that they did not commit. I have a pro bono case for a young man who's my age now. I'm 51. He was 16 when he went to prison, and I'm absolutely convinced he's innocent.